Ms Traynor, we move on to hearing 2, Aldi Stores, Holly Lane, Afton, Warwickshire, for land at Oakwell Road, Castle Douglas. Like to take us through the procedure?
Thank you, Convener. So this is an application for a major variation in respect of Aldi on the land at Oakwell Road, Castle Douglas, hearing number 2. I understand that we've got Lynn Simpson, agent from TLT, speaking to the application this morning. Good morning, Ms Simpson. Just checking that you can hear me.
Yes, good morning, Caroline.
Good morning, thank you. So members, the application for a major variation, the details are at Appendix 1, page 31, and there's also an LSO report at Appendix 2. So in terms of suggested procedure, Convener, you may wish to hear from the LSO this morning and thereafter questions, if there are any, and then allow Ms Simpson to speak on behalf of her client, thereafter questions from yourself, and then allow Ms Simpson the opportunity to sum up on behalf of her client prior to going into session. Thank you.
Right, we are over to LSO. I've got it down as Julia Farrell, but I can't see her online unless she's a icon.
I'm here, Convener, yes. Can you hear me
Right.
okay?
Oh, got you now, Julia. Yeah, on
Thank
you go.
Fine. Board members will be aware of this. It's a new store. It opened just back in November 2024. The layout of the store follows the similar layout of all the Aldi stores, with the alcohol display area at the rear of the premises. This is simply a small increase at the back of the premises to the length. No other changes. The notice was checked and was displayed as required, and I've got no adverse comments in relation to the application.
Any questions for Ms Farrell? Don't see any hands going up. Ms Simpson, would you like to speak to your application?
Yes, thank you, Convener. Good morning, everyone. Really just to give you a little bit of context for this application, what has essentially happened is when we applied for the provisional premises licence, the plans were drawn up based on what at the time was a standard Aldi sort of fit out. Essentially all new Aldi stores follow the same format. They use the same chiller cabinets, shelving units, all that thing, so that the specs can be agreed with suppliers on a bulk basis. That's part of Aldi's business model. And what has happened is, in the intervening period between the provisional licence being granted and the store actually being built, that standard specification has changed in various ways, but one of them is that the BWS, so the alcohol display units, they are slightly wider, the shelves are slightly thicker, and some of the units have changed shape, which just means they take up a slightly more space than the previous version, and that's why we're asking for the increase. In real terms, it's the equivalent of adding about 1 bay's worth, but see, because the actual units themselves are thicker and the shelves are thicker, it comes out pretty much the same. There's no other changes proposed here, and there's no objections or representation. So, subject to any questions you have for me, I would ask you to grant. Thank you.
Are there any questions for Ms Simpson? Councillor Barretti.
Good morning, Ms Simpson. When you mean thicker, do you mean stronger units?
I physically mean the shelves and the I'm trying to think of the words. The actual material, so the wood or whatever it is that's used, the shelves are thicker, so it reduces the actual shelf space because the shelves themselves are thicker. Does that make sense?
Kind of, yes. Thank you very much.
Right. If there's no other questions, would you like to sum up, Ms Simpson?
I'm not sure I've got much else to say, Convener. I think it's a relatively self-explanatory application. I say it was really just to give you the background.
Right.
Thanks.
With that, over to members. We're in session now. We have an application before us. Are members happy to grant the variation?
Happy to grant, Convener.
Happy to grant. Chair to grant, Convener.
No dissent. Ms Traynor? Could you advise the applicant?
Thank you, convener. So, Ms Simpson, the board has granted the application for variation this morning. You shall be notified of that decision in writing in early course with the revised premises licence on its way to you in early course. Thank you.
Thanks, Caroline. Thanks, Your Honours. Appreciated.
Right. I noticed Mr. Offord's name came up online. If he's having trouble dialing in, if he is there, do we wish to go back to item 6 just now? Are you there, Mr. Offord?
Yeah, I'm here.
Are members happy to go back to item 6 to deal with that? No dissent, right? We'll move back to item 6. Licensing Scotland Act. Application for new premises licence. This item is for dealing with an application which has been received for a new premises licence. Ms Traynor, can you go through this report and confirm the procedure for this item, please?
Thank you, convener. Can I just ask Colin Offord, can you hear me clearly?
I can, yes.
And also we have Sergeant Anna Parker from the police this morning. Good morning. Anna Parker just asking, can you hear me clearly?
Morning, everyone. Yes, I can hear you fine.
Thank you. So members, this is an application for a new premises licence, the details of which are at Appendix 1. There is also an LSO report advising no adverse comments at Appendix 2. At Appendix 3, there's a statutory police notice advising that Colin Offord has a conviction for a relevant offence in respect of assault. And there's also a preliminary issue to deal with this morning, members, in respect of a late objection received from Police Scotland that you clearly do not have before yourselves at this moment in time. Convener, I would suggest that the issue in relation to the preliminary police late objection letter is dealt with first. Police Scotland submitted an objection letter on the 30th of October 2024, objecting to the application. The last date for objections was a day prior to that, being the 29th of October 2024. So as the objection is late, the board can treat it as not made. So in terms of suggested procedure on this preliminary point, you can allow it to be submitted if you're satisfied that there is good reason for its lateness. So in terms of procedure, you may wish to hear from Anna Parker from Police Scotland as to the reasons for its lateness and consider whether good reason has been given. Thereafter, allow Colin Offord to put his viewpoint across as to whether he believes that good reason has been given, and then discuss the issue as whether you wish to admit the late objection. The second part of that is, if you're satisfied that good reason has been given and that the late objection should be admitted, consider whether it's in the interest of justice to postpone or adjourn the meeting, and that would, I would suggest that you ask the police their position on that, and thereafter Colin Offord the position. If it's the case that you're satisfied that good reason has been given, then the late objection shall be circulated, and thereafter I can go through with your consent, convener, the suggested procedure for this morning's hearing, if you're minded to proceed with that hearing. So just to kind of briefly recap, I suggest you ask the police the reasons for lateness and consider whether good reason's been given, and then allow Colin Offord his comments in relation to that, and decide whether you wish to submit that late objection letter. And if you do, is it in the interest of justice to postpone or adjourn the meeting to a future hearing date, clearly to enable Mr Colin Offord an opportunity to digest the terms of the late objection and receive representation if he so desired. I'm here to give guidance and assistance, of course. Thank you.
So with regard to that, Sergeant Parker, would you like to speak to the reason for the lateness of the objection? And just the lateness, not the substance of the objection.
Thank you. Good morning, everyone. The reason for the late submission is that it has been an administrative error on our behalf, and we profusely apologise for any inconvenience that this has caused. Police Scotland submit objections with valid reasons and concerns that are identified, and this letter is no different. I consider that the information documented within our letter breaches licensing objectives of preventing crime and disorder, securing public safety.
Sorry, if I can just interject there. The only matter, the preliminary point, as you've said, convener, is to give reasons for lateness and not to go into any substance in terms of the objection. And thank you.
Right.
My apologies.
And is there any questions? I don't think there is. The reason was given there, but is there anything members would like to ask before I ask Mr. Offord if he wishes to address the reason for lateness? No. So, Mr. Offord, you've heard the reasons for lateness. It's up to you. Do you feel that that's something that is fair to, or exceptional circumstances?
I've got no qualms. I understand the reasons for the objection initially. Hopefully I can overcome that. I fully understand, appreciate it's an administrative error, so I'm willing to proceed.
Right. Ms. Traynor, do we need to take a vote on this as to whether we are willing to accept it based on the two speakers?
It would be entirely a matter for yourselves, convener, to have a discussion, and if you wish to have a vote. You've heard from the police the reasons for lateness is that it was an admin error, and Sergeant Anna Parker has apologised for that. You've heard from Colin Offord, who's advised that he's got no qualms in respect of the reason for it later, and that he's happy to proceed with the late objection letter being submitted. So you may wish to just discuss with yourselves as to whether the good reason is sufficient to enable you to proceed.
Over to members. Councillor Thompson.
Thanks, convener. Yeah, I mean, I think I'd be happy if we just accepted that there was a sufficient reason for the objection being late, and that we do hear it, and then obviously decide where to go from there, whether we adjourn or determine it. Thank you.
Councillor Barretti.
Similar vein, Chair. I would rather look at the police letter and once it comes in, and then take the case forward.
Right. I don't see anyone otherwise minded. Caroline, do we now see if we're willing to continue today, or do we wish an adjournment?
Just to confirm, convener, is a decision of the board to admit the late objection letter because good reason has been given. So
yes.
the later, thank you, convener, just for clarity there. So you're admitting the late objection letter. So indeed, the next part of the process is to consider whether it's in the interests of justice to postpone or adjourn this morning's hearing. And you may wish to hear from the police in that regard, their view, and thereafter hear from Mr. Offord whether he would prefer this morning's hearing to be adjourned or postponed to enable him to fully digest the terms of that late police objection letter that shall be circulated, Mr. Offord, to board members this morning. And if it's the case that your view is that you need time to digest the terms of that late police letter, perhaps seek representation, then the board can adjourn this morning's proceedings to a future hearing date. So, convener, you may wish to hear from the police on that matter, and thereafter Mr. Offord, and decide whether it's in the interests of justice to postpone or adjourn this morning's hearing. Thank you.
Sergeant Parker.
Thank you. I have no preference in respect of this. I think that it could be heard today or it could also be adjourned, and I'm open to either.
Right. And Mr. Offord.
Sorry, I couldn't quite make out what the sergeant said there.
Sergeant Parker said that she's happy to proceed today, or she's happy for it to be adjourned whichever you feel is in your best interest, I suppose, to seek natural justice.
I'm happy to proceed.
Right. Ms. Trainer, we've heard that both are happy. Over to members. Are members happy to proceed? Councillor Barretti?
I think it's a difficult one because although we are 6, and if we cancel, then what happens when we reconvene this? Does that mean to say it starts from scratch? And as of yet, we haven't had the letter, so I would be happy to read the letter, ponder on it, and then make a decision. So at the moment, my feeling, convener, is to suspend this hearing until we've all had time to read that and digest that letter, or digest that police information.
Councillor Dorward?
Thank you, convener. Based on what both Mr. Offord has said and police, I'm happy to proceed and perhaps adjourn, read the letter and come back if that's reasonable, to allow everybody to have, if the letter isn't too long, I'm sure we can read it and make an informed opinion on it reasonably quickly. Thank you.
Ms. Trainer?
Thank you, convener. So it was just to a wee bit clarity in terms of the procedure. So you've agreed to admit the late objection letter. You've agreed to proceed. And the next stage would be to circulate that letter, and it's entirely reasonable, given that you've not had sight of that late objection letter, to adjourn proceedings for whatever timeline you wish to read and digest the terms of that late objection. Just also ensuring that Mr. Colin Offord also has sight of that late police objection and is able to be given sufficient time to digest its terms and form a stance in relation to it. Once you've made the decision as to, once the letter is circulated to yourselves and Mr. Offord, and I understand that Sergeant Anna Parker has that letter, and you've decided the timeline in which you're required to read and digest and consider its terms, the suggested procedure in relation to this morning's hearing, convener, would thereafter be to hear from the LSO with any questions from yourselves, and then to hear from Sergeant Anna Parker speaking to the terms of the police notice detailing the relevant offence, and also speaking to that late objection that's going to be circulated in today's proceedings. Thereafter, any questions from yourselves allow Colin Offord to speak to his application, addressing matters raised in relation to the police notice and also that late objection. Thereafter, any questions from yourselves. Thereafter, you may allow the police to sum up their position, then allow Mr. Colin Offord the opportunity to sum up his position prior to going into session. So if at this stage, convener, you may wish just to ask for that late objection letter to be circulated to all members, ensure that the police have it before them, and also that Mr. Colin Offord does, and decide a timeline in which you're required to read, digest and consider its terms. Thank you.
All right. I did note that Councillor Barretti intimated that he would like to see the objection, then decide whether to proceed today in the interests of natural justice. Now, Mr. Offord has said he's happy to proceed today. Based on that, do we need to, because there's a difference of opinion there with regard to whether we proceed today prior, once we've seen the letter or not, or is that just a case of we could see the letter then adjourn for a future hearing? Just on what you said there, Ms. Trainer.
Thank you. So the correct procedure, now that you've agreed that there is good reason to admit the letter, the next step is to determine whether it's in the interests of justice as to whether today's hearing should be postponed or adjourned. That would come prior to having sight of that late objection letter. Now, you've heard from the police who have advised they've no preference in that regard. And crucially, you've heard from Mr. Offord, who's advised that his preference is to proceed at today's hearing. The next step in procedure would be for that late objection letter to be circulated and for it to be read and its terms digested. So the decision as to whether you should adjourn in terms of natural justice is not one that will be taken after the letter is read. It should be taken prior. I hope that assists.
Right. So, Councillor Barretti, you weren't minded to proceed today without sight of the letter.
Yes, I maybe just make a expand on that. As you said, in the interest of justice, if Mr. Offord receives the letter and then decides that he wants legal advice, he's not going to have enough time to get legal advice. If we are then going to go into proceedings, we can see the letter it is slightly skewed, and he may or may not want to have legal advice. But until that happens, until he sees and makes that decision, I don't know we can actually proceed.
Can I just interject there? I've actually received a copy of the objection from the police. It's something that I have read through.
Based on that, then fine, I'll leave it in your hands, convener.
Right, and Councillor Dorward had moved that we proceed today. So I would be happy to second Councillor Dorward. Are we happy to move forward?
Yes, convener.
Right, Caroline, could you arrange for the letter to be distributed, please?
Thank you, convener. Can a member of staff, the licensing team, please circulate the late police objection letter to members today, and perhaps just check that Sergeant Anna Parker has that letter in front of her, and also Mr. Colin Offord has that letter in front of him as well. Thank you.
Councillor McCammon?
Yeah, convener, it was maybe just a question for Caroline. Do we get time to read this before we proceed? Or obviously we do, but significant time, like 10 minutes, or have we got to decide right now once we read it?
I don't know how long the letter is. Is it a long letter or is it just?
Well, I think everybody reads at different speeds and
Yeah.
digest things at different times. So I'm just thinking, is it wise for us to take a couple of minutes to actually read it, and or is that permitted, Caroline?
We can adjourn for 10 minutes if you wish to actually address it, have a good read through the letter. Caroline?
Convener, it would be entirely appropriate once the letter is circulated, perhaps to have sight of it and then make a decision as to how long you wish to adjourn proceedings to read and digest and consider the terms of that letter once you've had sight of that letter, once it's circulated. That would be entirely appropriate.
I note in my email that the letter has been circulated. Could I give 10 minutes to read it? And then we'll come back, and if somebody wants more time, we can ask then, but I would think 10 minutes should be long enough to read the letter. Has everyone got the email first?
Yeah.
Received.
I think 10 minutes is ample for me anyway. I'm not speaking for anyone else.
Yep.
But thanks.
So we'll come back at 11:27 on my computer. It's 11:17 just now. Oh, it's just turned 11:18, so we'll make it 11:28, right? happy that they've had sufficient time to digest the letter?
Yes, thanks, Chair.
Yes, Chair.
Right. So, oh, Councillor Beretti.
Wondering Caroline should do a sound check on us just to make sure we're all here.
Might be a good idea.
Thank you.
Sabrina?
Thank you, convener. So, Councillor Beretti, can you confirm that you can hear me clearly?
Yes, I'm here and I can hear.
Thank you. Councillor Dorward? I can see Councillor Dorward. Can you hear me clearly, Councillor Dorward? I can see Councillor Dorward's on mute. Convener?
Yeah.
I'll return to Councillor Dorward. Councillor Howie, can you hear me clearly?
Yes, absolutely.
Thank you for confirming. And convener, you can hear me?
Yes.
Thank you. Councillor McCammon?
Yeah, it's all clear. Thanks,
Thank
Caroline.
you. Councillor Thompson?
Yes, loud and clear, Caroline. Thank you.
Thank you for confirming. And going back to Councillor Dorward. So I can see on screen that Councillor Dorward appears to be present and is on mute, but there's no response. Convener. Councillor Dorward, can you hear me? Not sure, convener, if you wish to just wait until we can get confirmation that Councillor Dorward is indeed present.
Give it a couple of minutes maybe just to see.
Convener, if I may, I'll just ask again, if that's okay. Councillor Dorward, are you present and can you hear me? Convener, I don't know if someone wishes to give Councillor Dorward a call. The options would be you can see you've asked her.
Yeah. She did say she had trouble earlier on getting in. Councillor Dorward, are you able to confirm you can hear?
I am here. Apologies. Yes, I'm here.
No problem. Right, thanks for that. Right, Caroline, I think we're ready to go on to the next part, which is hearing from the LSO. Now,
Thanks, convener.
Julia, it's you again. Miss Farrell.
Yes. Thank you. So this application is relating to premises, new premises, which are in Carsleuth formerly operated as a non-licensed coffee, you can actually see them along the A75. So the premises serve a range of meals and snacks, coffees, etc. And they also host some live music, various kind of different nights, and have been operating since June 2023. There has been 9 occasional licences granted to date for just different types of events to allow the sale of alcohol. These have been granted to Michelle Offord, and we've currently got 3 pending in the name of Nicola McCartan, just for some events that are upcoming in the event that the licence wasn't in place. The building is a restaurant area. It's got an outdoor seating to the front. I have provided some photographs just for members' reference. Indoor capacity is about 40, so relatively small premises. It doesn't contain a bar counter. The on-sale hours applied for are Monday to Thursday, noon till 10, and Friday to Sunday, noon to 11. These are well within the licensed hours policy, and also children and young persons access is within the policy hours as well. So no problems with the notice. It was displayed as required, although I did provide a further copy to be displayed at a lower level just for ease of access for members of the public, and this was duly displayed. I've got no adverse comments.
Are there any questions for Ms Farrell? Don't see any hands up. Sergeant Parker, would you like to address your objection? We're struggling to hear you. It's breaking up rather than being on mute. Don't know if you can move closer to your phone or something. Still a little breaking up. Unless it's my headset that I can't.
The camera's actually switched on now. Some technical issues, but can you hear me appropriately?
Struggling to hear. Councillor Barretti.
It is difficult to hear, I'm afraid.
Councillor Thompson.
Yeah, it's the same here. It's been consistently poor connection up to now. Thank you.
I think Sergeant Parker's got to try and dial in again.
Go.
Sergeant Parker. It would appear that there's still difficulties connecting. Councillor Thompson.
Thanks, convener. It was just obviously we've heard the report from the LSO on this one, so it's just a wee bit of a process thing. But having sort of accepted and taken the time out to read the various letters, etc., does the objection from the police have any bearing on the LSO's report on the application itself, or would that be picked up separately? Because we could look at the application and say, well, that's fine. The only issue is we need to have a discussion around the police objection in relation to the applicant. So I'd welcome a wee bit of clarity in that. Thank you.
Ms Traynor.
Apologies, Councillor Thompson, your question's not clear to me. That may just be me. I just wonder if you could just clarify what it is you're asking, if that's okay.
Yeah, so we've got the reports in front of us and we've heard the LSO report in terms of the application, but I suppose what I'm asking is, can the application go ahead without first determining the substance of the police objection around somebody being fit and proper, etc.? Thank you.
Convener, through you, if I may.
Yeah.
It would be very important in terms of natural justice to allow the police to be able to speak to their objection. Councillor Thompson, they are, they are a party to proceedings today. So it would be very important that they are able to speak to the terms of their objection letter and also to the terms of their notice.
That's fine, thank you.
Will we try once again, Sergeant Parker?
Hi, can anybody hear me?
Oh, that's better.
Oh, brilliant. See if my camera's working also. I'm not sure that it is, but as long as you can hear me.
Yeah.
Right. So,
Oh.
in long and short, I'm looking to basically read the letter that we have all had circulated and digested. In terms of section 21(4)(bi) of the Licensing Scotland Act 2005, I give you notice that the applicant has been convicted of the following relevant offences, which is assault, a domestic assault. The disposal for this was a community payback order of 12 months, and the individual had to attend that and engage with alcohol services. I also give you notice in terms of section 22(1)(a) of the 2005 Act that the Chief Constable objects to this application on the grounds that, having regard to the licensing objectives, the applicant, Mr. Colin Offord, is not a fit and proper person to be the holder of a premises licence. In terms of section 22(1)(a) of the 2005 Act, the following information is included in this notice as it is relevant for consideration by the Licensing Board for grounds for refusal. About 2017 hours on Sunday the 29th of October 2023, whilst within Glasgow city centre, a witness observed a male, later found to be Mr. Colin Offord, push a female to the ground and thereafter lean down and strike her repeatedly to the body with his fist, back of his hand, knee and foot. The female victim was heard to scream for help and police were contacted. Both Mr. Offord and the female victim were later traced within the rear of a taxi a short time later. Mr. Offord was informed he was under arrest for assault, where he immediately became hostile towards officers, repeatedly shouting and swearing at them. He was thereafter handcuffed and had to be physically removed from the taxi, which he resisted, and additional officers were required to attend. When Mr. Offord was transferred into a cell van, he continued to shout abuse, making homophobic and disableist comments towards them. The female victim was found to be Mr. Offord's wife. She did not require medical treatment and declined to provide any further information. During the incident, Mr. Offord needed to be handcuffed and physically removed from the taxi by police officers due to his extreme levels of hostility. His conduct continued in this manner and additional officers were required to attend to assist and utilise their operational safety training in order to get Mr. Offord into a cell van. There was also a second charge for a non-relevant offence which was linked to this incident. Police Scotland wished to provide for the information of the board. Mr. Offord was additionally charged with Criminal Justice and Licensing Scotland Act 2010, a section 38, with aggravators of disability and sexual orientation. He was found guilty on the 28th of November 2023 and the penalty imposed as documented earlier. When an offence is aggravated by prejudice towards certain characteristics, then it is recognised by Police Scotland and documented. So due to the language used by Mr. Offord during this incident, the charge was endorsed with these aggravators in relation to comments regarding disability and sexual orientation. During this interaction, Mr. Offord has shown a belligerent and hostile attitude towards police and failed to cooperate with us. His behaviour falls far below what can reasonably be expected of the applicant of a premises licence, and in light of this information, the Chief Constable considers that it is necessary for the purposes of preventing crime and disorder, securing public safety and preventing public nuisance, that this application be refused.
All right. Are there any questions for Sergeant Parker? Councillor Thompson?
Thanks, convener. Yeah, so and it might involve a solicitor as well, just a wee bit of guidance. So, so this is in relation to the premises licence application, but it's about the applicant effectively, and one of the charges or that you have to report is obviously the Criminal Justice and Licensing Scotland Act one. But the aggravators, I'm just sort of wondering, this is where it's, for me, I'm sort of trying to distinguish between that which relates to licensing and that which relates to a fit and proper person. And I'm just sort of wondering if there's sort of space in between that. I'm just sort of, I think the fit and proper bit is the bit that I'm sort of having difficulty with, because I think that's where things like those aggravators might play a role in terms of, you know, Equality Act or whatever, but wouldn't necessarily relate directly to licensing, but it's about judging whether a person's fit or proper. So I'm sort of, it's maybe a wee bit both for yourself, Anna, and maybe for Caroline as well, just to maybe help clarify the significance of attaching that aggravator. Thank you.
Sergeant Parker?
So in terms of the conviction that was disclosed, so the domestic assault and the Section 38 of the Criminal Justice and Licensing Scotland Act, they were committed at the same time, and the sentence that was passed for the disposal was based on both offences. Because the domestic assault comes under a relevant offence, that's why it's documented. However, we make mention to the Section 38. The comments are in addition to the Section 38, whereas we would be looking at the fit and proper in respect of this.
Okay, can I come back just quickly, convener, if that's okay?
Yeah.
Okay, so, and I think this is where maybe I need the advice of Caroline, maybe not at this juncture, but certainly at some point, but because, you know, in other applications, for example, it might be brought to our attention that somebody has committed an offence, and we might be then being asked, you know, for example, whether or not to endorse or take any action about the licence holder, for example. But this isn't that particular type of application. This is for a premises licence. So I'm just sort of thinking, if this is about the fit and proper part of that, that might then relate to the aggravator bit, which you know, creates questions about whether or not somebody is fit and proper based on an offence, sort of thing. So yeah, I'm maybe just airing my sort of thinking and sort of confusion at the moment, but I don't know if Caroline can maybe assist with that part of it, if that's okay, convener. Thank you.
Ms. Traynor?
Yes, thank you, convener, and thank you, Councillor Thompson. So the police are contending that their view is that the application should be refused on the basis that, having regard to the licensing objectives, the premises, the applicant is not a fit and proper person to be the holder of a premises licence, and the police have detailed in their late objection letter reasons as to why their view is that the applicant is not fit and proper. And in their view, relevant to their position are the aggravating factors that they've detailed in the police letter in relation to the threatening and abusive behaviour, having the aggravating factors of disableist comments and sexual orientation. So that's the position of the police. So you'll recall, in relation to if the ground having regard to the licensing objectives, the applicant is not a fit and proper person. Here, of course, the applicant is a company, and the connected person is a director, Mr. Colin Offord, here today. So having regard to the licensing objectives narrows that fit and proper person test. There is no statutory definition as to what constitutes fit and proper. So it's really entirely a matter for yourselves how you would wish to define that, and as you're aware, it's not like the civic government side where fit and proper is actually quite wide. It's narrowed because you must have regard to the licensing objectives, and you must state which licensing objectives you're having regard to. So issues pertaining to whether Mr. Offord is not a fit and proper person is a matter for yourselves, having regard to all the material before you, not just in respect of what the police are stating in their letter, but also, of course, you must hear from Mr. Offord his position, his mitigating factors as to what gave rise to the offence being committed, the aggravating factors, and consider all material before you. So it is entirely a discretion that you have yourselves, members, but it is narrowed by you must have regard to the licensing objectives. So you don't have a complete discretion. It is a narrower test. Does that assist? I would suggest that you hear the police's position. The police are entirely within the right, if they wish to submit their viewpoint, that aggravating factors are relevant to the fit and proper person test. They are within their right to do so. And of course, you also have to hear from Mr. Offord his position and his version of events and any mitigating circumstances that gave rise to the offence being committed. Does that help at all?
Councillor Thompson.
Yeah, no, thanks for taking me through that, Caroline. And yes, I think that helps a bit. I think it was just the narrow point around if the applicant was a company, a legal personality rather than an individual, and it seems to be that the applicant is an individual, you know, in terms of the form that we've got in front of us. So it was just, we'll get into that, but obviously, you know, we want to hear from everybody involved. It was just that a question particularly around the way the police had presented it in their letter. Thank you.
Right. Councillor Barretti.
Thank you, convener. It's more to do with the letter itself and the information that's been provided by Police Scotland. On the first page, it says that the incident took place in Glasgow city centre on the street, and when they arrived, both individuals were in a taxi. So I'm wondering, is there any more information about the time between the two events? And also, it says that in the court decision, Mr. Offord engaged in 12 months of community payback with alcohol services. Was that the only payback, or was that the only thing that Mr. Offord did? Did he do anything else other than the alcohol services? Thank you, Chair.
Sergeant Parker.
I'll come to your second question first, as I will need to establish further information for your first question. But it's my understanding that the community payback order for 12 months is a separate entity to the attend at and engage with alcohol services. So he would do the community payback within the community and then also attend at and engage with alcohol services separately. Does that answer your question?
What I'm trying to establish is the fact that was Mr. Offord or Mrs. Offord, what were their state of intoxication at the time that the incidents took place? Did that have material impact?
Apologies, just give me 1 minute. I'm just going to review the paperwork so that I can give you an accurate answer.
Okay, thank you, convener.
So I can confirm that as documented earlier, the incident commenced at 2017 hours on Sunday the 29th of October, and the incident was captured on CCTV and would have been documented. That's how we would have known where Mr. Offord had gone, and we document that Mr. Offord was placed under arrest at 20:45 hours. So that is when we have come into contact with him. So that is the period of time between the two. There's nothing documented here with regards to levels of intoxication, unfortunately.
Okay, thank you, convener. Thank you, Sergeant.
Right. Councillor Howie.
Thanks, convener. Sergeant, was there anybody at the locus with the protected characteristics who would have been offended by the behaviour of the accused? So not accused, the applicant at the time.
My apologies, I cannot accurately answer that. That is not documented as to his comments were directed towards police officers, and I cannot advise in respect of that.
Thank you.
All right. If there's no further questions for Sergeant Parker, Mr. Offord, it's now your opportunity to give your side of the events.
Yep, obviously here in the back, it fills me with shame and regret. It certainly goes against every core value that I hold dear, every way I've been brought up. It's an hour in my whole life that I can't fully explain. I don't think I'll ever be able to fully explain. Round about that time, obviously, I had another business in Coatbridge. There was a carpet and flooring showroom, which I'd built up over 3 years prior. On top of that, we took on the restaurant as well, which kind of increased the workload for me. I didn't realise how much work would be involved. Initially, my wife was going to run the restaurant, but it became really apparent early on that it was going to take more experience that I had. So running two businesses 100 miles apart brings its own stresses, which I didn't realise at the time how stressful it was becoming. On top of that, at that time as well, I was the chairman of the board for a Glasgow-based charity called Baby Loss Retreat. They deal with helping families after the loss of an infant, through therapy, counselling, and certainly taking families to retreats. Again, a lot of stress involved. So with these three kind of things, and it's only on reflection now, the stress I was putting myself under committing to all these things was, well, looking back, it wasn't really necessary. And I think that's where that kind of explosion of anger came from. It's certainly the first time in my life, I'm 50 years old this year, I've ever been in any kind of bother, certainly of that magnitude. So following on from that, after reflecting, is that the reason why what happened? Because it should have been a joyous occasion. I was actually Best Independent Retailer at the Scotland Business Awards that night. So it should have been a joyous occasion. Also, it turned sour, and that's my fault and my regret. But in the aftermath of that, to show sincerity and remorse, and that I genuinely feel that the stress levels caused that, I decided to resign as chairman of the board for the Baby Loss Retreat, and I also folded my company in Coatbridge to bring those levels down, to try and put blocks in place so nothing like this could ever happen again. Folding the company was obviously duly noted at court as well, and the judge, the sheriff, took that into consideration. The payback order, I met head on. There were services there that I fully engaged with. I think the easy way, the folly way, would have been get the hours out the way and say I wouldn't do it again. Beforehand, I would have said, and anybody who knows me, family, 100%, I would never engage in such actions, but I did. So now I'm only 99.9% sure that it won't happen again. So I did engage fully with the alcohol services. It's only upon reflection that round about that time, I probably was using alcohol as a coping mechanism for the stress levels. So I fully engaged with them, certainly with the caseworker as well, to the stage where actually the Criminal Justice Department offered me a paid role during my payback. Every Friday when we went there, I used to bring food for the younger ones on the payback from the restaurant, and they were looking to devise a course that I could show people how to cook, how to budget and things like that. But unfortunately, something that I would have loved to have done, try and help out. But with what happened prior, taking on too much workloads, I had to refuse that, which again, it's a ripple effect of my actions. It goes further than just up to my wife and my family. Trying to help people out is what I do. It's part of my nature. It's what I've always done. And just now, obviously, I'm feeling the effects as well. Other people, I employ 10 people now. The success of the restaurant has always been based on gaining a license at some point to take the business forward. So the responsibility of the staff is mine, and I don't want them to be punished for my actions should I not get a license, because that's where the business needs to progress and to profit. Certainly the things that I've got in place I would like to do with the business really depend on getting a premises license. Again, I've got this little window of opportunity to kind of show my characteristics. Certainly I made a huge mistake that night. It's one I've paid for dearly. It's one I'll always carry with me, and so I should. But hopefully it won't determine my future or the future of my business. The business itself, being part of the community, I've always been brought up to think that if you take from the community, you put back in. So I still do a lot of work for the local charities, a lot of sponsorship, a lot of donations, a lot of fundraising nights. These range from donation of vouchers for some of the nursing homes to raise funds. The 2 local youth clubs, I sponsor them, and every Christmas they come here for a free Christmas meal. We've had 2 fundraising nights last year and another 2 upcoming for our kids' orphanage in Kenya. It's a local businessman who runs that. The 2 events raised 3,100, which built new toilets and shower facilities. So these are the things that the restaurant does and I do for the community. And really, I would hope that my actions that night won't affect my ability to do that.
All right. Well, are there any questions for Mr. Offord? Councillor Howie?
Mr. Do you still cohabit with your wife, and is she a business partner?
No, the business is mine now.
Do you still cohabit with her?
No.
Okay.
Apologies, Councillor Barretti. Councillor Howie's name came up, so that's why I have took him first. Councillor Barretti.
No, thank you, convener. No, that was fine. Mr. Offord, by your own words, you said that you were in, and what I'd like to understand is, on the day that this happened, you had, if I understood, been drinking. Would you say that from what you have said, that your level of alcohol intake before this event and after this event with the alcohol services, what has actually changed, and what was that really a triggering mechanism?
I think at that point, and again, it's only upon reflection, I probably was using alcohol as a coping mechanism for the stress levels. I didn't see it problematic, but when I talked to the services, it probably was at the time. Certainly, I'm very aware of what I drink now. Again, drink was part of the incident, or part of the reason why what happened. I don't think it was a sole contributory factor. But since then, I very rarely drink. I'm very conscious of anything like this happening again. I only drink white wine, 9% or under. But with the hours I do, it's so infrequently that I do drink. I am very conscious of if I do have a drink, a glass of wine, or go out with friends, I'm really aware of the levels.
Okay, just one final question. Have you finished your payback, and are you intending to do any refresher courses in the future?
I have finished the payback. Certainly, I'm still engaging with We Are With You, the alcohol services. They actually, around about March, the payback started, the conviction was the 28th of December. In March, they agreed that my alcohol levels, and they were satisfied that they could discharge me. So, like, around about May time, I felt a little bit of depression creeping in, so I re-engaged with them voluntarily. And I still continue every few weeks. They check in with me, make sure everything's okay. And again, as I mentioned, I think it's, for me, it's putting these blocks in place and utilising services that are there, that's probably in the past I would never have utilised or thought I needed to. So it's just kind of safeguarding myself against any further, committing any further offences.
Okay, thank you very much, Mr. Offord. Thank you, Convener.
I have one sort of question. I think going forward, what's the role that you will play in the day-to-day running of the premises? Will you have a premises manager in place who will be responsible for the sort of alcohol serving side, and therefore will they have the ability, if needed, if you're on the premises, something they take charge because they are the actual designated premises manager?
Yeah, well, I've got an assistant manager that I put in place the last January. She's been with me. It's Nicola McCartney, who is the personal licence holder. Nicola came to me. She hadn't worked for 18 years after raising her family. And she was a little bit nervous, but I said, that's the hardest job you can do. So I took her on. I saw potential there to make her into assistant manager. So I've kind of moulded her into the way I kind of run things. I'll be here on a day-to-day basis. But certainly Nicola is aware of what's needed when serving alcohol. Certainly when we had the temporary licence at Christmas and New Year, I said, never be afraid to turn anyone away. And she did. I said, always just cover your tracks. To the extent where a couple were in and they ordered 2 glasses of wine and then a second, and she refused because they're obviously driving. The customer took umbrage, and I said, don't worry, if I lose a customer, it's fine. Just, you've got to do it the right way. So they're well informed as what's required. I'll also be here overseeing the day-to-day operations, from front of house to the menus to the social media to the market and absolutely everything. But I've got a good team in place now. It's part of my job, which I've always been in business, to make them better. And that's what I put a lot of effort into them. And I do get the rewards from it because they're a loyal staff. They're happy to work here. They're proud to work here. And I'll continue to mentor them moving forward.
Right, yeah. Are there any other questions? Don't see any hands going up. Sergeant Parker, would you like to sum up?
Thank you, Convener. Can you hear me okay?
Yes, fine, thanks.
So to sum up, the circumstances provided in our letter demonstrates behaviour by Mr. Offord which includes violence towards women and a complete lack of respect for the police and the law. I appreciate what Mr. Offord does for his community and what he has mentioned just a short while ago. He also acknowledged himself that he could not guarantee that something like that would never happen again. Given this, Police Scotland are of the opinion that this standard does not meet licensing objectives of preventing crime and disorder, securing public safety, or preventing public nuisance. Police Scotland do not believe that Mr. Offord is a fit and proper person to be in possession of a premises licence. He has acknowledged himself that he is quite hands-on and he is involved in the day-to-day running of the premises, although he does have additional staff. And I respectfully request that you take this information into consideration and refuse this application.
Right. And Mr. Offord, would you like to sum up?
Yep. Also on that one incident, it's hard to disagree with Sergeant Parker, but one thing I do disagree with is my lack of respect for the police and the judicial system. It's on that one occasion, it was a huge mistake I made, but I've always been brought up to believe that law and order has got to be the cornerstone of any society. I failed on that occasion, but I was given a punishment by a sheriff, and I've took that on the chin and I've learned from it and moved forward. As I said, it's the one and only time in 50 years on this planet that I've fell foul of the law, and it's another of my life that it makes no sense. It came from nowhere, but I've done everything I can to try and move forward and better myself and learn from it. And yeah, I just want to get basically on with my life and try and make a success of things.
Right, yeah, thanks for that. Over to members, we're now in session. We have Councillor McCammon.
Thanks, convener. Convener, I'm on hands free at the minute. Can I just check that you can hear properly?
Yes, we can hear.
Cool. You know, taking everything into consideration and listen to Mr. Offord's establishment is in my patch, so to speak. So I'm well aware of the reputation that it has, the good work that he does for the community, and the very fact that he seems remorseful. You know, I'm very minded that everyone deserves a second chance to better themselves, and particularly if it includes bringing the community with that betterment. So, you know, just in summary, because I may not get a chance to speak again, convener, I'm minded just to grant this application when it comes to it.
Right, yeah. Any members otherwise minded? Councillor Howie. Oh, wait a minute. I've got, yeah, it is Councillor Howie this time.
Sorry, Commander,
Yeah.
not otherwise minded, particularly at this time, but I was just wondering, maybe for Caroline to come back, if we do not grant the premises license to Mrs. Offord, is there any reason why his manager is in there could not apply and obtain the license under their name?
Caroline?
Yeah, thank you for that, Councillor Howie. So I think the first issue would be to determine whether in law a ground of refusal exists, and just to advise that the fit and proper person test is not a direct character assessment. You're not here to assess, you know, the character of whether you approve or otherwise of the conduct of Mr. Offord. So I think it's important that you actually look to ascertain whether a ground for refusal exists in law, and if you're minded that one does exist in law because you have material before you and evidence before you to support that, then you would be obliged in law to refuse the application. On the other hand, if there's no ground for refusal, then you must grant the application. With regard to your specific request as to whether, if you were to refuse the application, whether another individual other than the applicant company could make an application for a licence, where the board has refused a premises licence application in respect of the applicant. In respect of premises, they must refuse any subsequent premises licence within a 12-month period thereafter, unless you make a section 25 direction that they can indeed reapply. So they could, the DPM could make an application, or indeed the applicant company could make an application if you were to state that you were making a section 25 direction, that they could make that application. But I think it's very important to consider all the material before you, and bear in mind that the fit and proper person test is not a direct character assessment. Everything must be linked to the sale of alcohol, and you must be minded to consider having regard to the licensing objectives, which licensing objectives relevant to the sale of alcohol tied to that wide fit and proper person test. But it's not a direct character assessment. It's not also in law a punitive assessment. You're not here to punish an applicant for past issues. You're concerned with having regard to the licensing objectives. Is this applicant not a fit and proper person to hold a licence? Does that assist?
To a degree, I'll say. Thanks, Carl.
Councillor Thompson.
Yeah, thanks, convener. No, I think having heard now from all the representatives, as it were, and given that it's not, it's not like a history of offences, if you like, in relation to this, and there's been sort of an explanation given from Mr. Offord. I'm not sure how solid a reason to refute, not to grant the premises licence would be, given everything that's been said. However, obviously that's now on record, as it were. I think my question was really around, if the letter related to Mr. Offord as a licence holder as opposed to the premises licence applicant, that might have been a separate report we would have had in relation to the police report coming to that, but that's not what's in front of us. So so on that basis, I'm noting the information we've got in front of us. That will remain on record, and I would go with Councillor McCammon, and I don't think we have enough reason not to grant this application. Thank you.
Councillor Barretti.
Thank you, convener. As the LSO has said, there's no grounds for refusal. The building, location, and the means by which it's going to be done. So I would agree to have the licence accepted.
And Councillor Dorward.
Thank you, convener. I commend Mr. Offord's candidacy, his honesty and his efforts to recover from the incident. Thank you for that. In terms of the terms which we are looking at, which is the sale of alcohol, I have no issues with Mr. Offord's ability to do that, and note that there were also occasional licences granted the premises with no adverse effects. So from that perspective, and thanks to Councillor McCammon for giving us some more local information as well. That's always extremely useful. From that perspective, I have no issues with seconding what my colleagues have said. Thank you.
I think it's right that the police do bring these issues to our light. However, I think Mr. Offord, from what you've heard, members are convinced that you are looking to be on the right track now, and you've worked hard in the community. Your remorse for what you've done seems to be of light. So on this occasion, I'm minded to support the moves so far from members that we agree your premises licence. I haven't heard anyone otherwise minded. I don't see any hands going up to disagree. Ms. Traynor, could you clarify the decision for the applicant and for Sergeant Parker?
Thank you, convener. So just before I do confirm that decision, so can you just advise that the board is of the view that no ground for refusal exists in law to refuse this application, and therefore you're granting today's application?
Yes, that is the view of the board.
Thank you, convener. So Sergeant Parker and Colin Offord, you've heard from the board today. They've determined and considered all the information before them, and the decision of today's board is to grant your application, Mr. Offord, for a premises licence. You shall be notified of that decision in writing in early course with your premises licence forwarded to you in early course. The decision takes effect from today. And just to advise Sergeant Parker, in terms of the Licence in Scotland Act 2005, there is no right of appeal against today's board's decision by the police, but that is under the 2005 Act. Thank you.
Right. Thank you, folks. We'll now move on back on to item 7, and it's hearing 3, I think we're on to now, which is Licensing Act 2005, application for variation of premises licence, Kirkcudbright Bay Hotel, 25 St Cuthbert Street, Kirkcudbright. As trainer.
Thank you, Convener. So this is indeed an application for a major variation in respect of Kirkcudbright Bay Hotel at St Cuthbert Street in Kirkcudbright. I understand that we have a Darius Cartier with us today. Mr. Cartier, I would be grateful if you could just advise that you can hear me clearly.
Yes, I can. Thank you very much, Caroline.
Thank you. So Mr. Cartier, as I understand it, is a director of the applicant company. So details of the application, members, are found at Appendix 1. We are on hearing number 3, and the LSO report is detailed at Appendix 2. There is also a planning comment at Appendix 3 advising that the formation of a new external drinking area may require planning permission. So in terms of suggested procedure, Convener, you may wish to hear from the LSO, thereafter any questions from yourselves. Note the terms of the planning comment, bearing in mind that planning matters are not within your statutory remit. Thereafter hear from Darius Cartier with any questions from yourselves, members, and thereafter allow Mr. Darius Cartier the opportunity to sum up prior to going into session. Thank you.
Ms. Farrell, would you like to speak to your report?
Yes, thanks, Convener. So members may be aware that this is a long established premises in the town centre of Kirkcudbright. The applicant has been operating the premises since June last year and has taken the opportunity to put his stamp on the premises and make changes as the application states. So in terms of the changes, the request to open 11 AM on a Sunday instead of the current hours of 12:30 is well within the board's policy, which would allow for a 10:30 opening. So the 11 AM would bring the opening hour in line with the Monday to Saturday opening times. At the same time, the outdoor drinking area is to be brought within the licensed premises to be able to be used for sale of alcohol. I have included a few photos just for the information of members there. The applicant has stated that the terminal hour for this outdoor drinking would be 10 PM voluntarily, and that's just to reduce any potential for nuisance to residents in the hotel or neighbours. Again, children and young persons, they have currently to be out of the premises for 8:30 PM, which is quite restrictive. So the applicant has taken the opportunity to extend this, to try and extend this. The board's policy allows for flexibility for children and young persons access, and this would seem entirely reasonable what's been applied for, and given that no persons under 18 years of age will be in the public bar, which I've got absolutely no concerns about the rest of the premises. Other changes are just consistent with hotel activities, and the notice was displayed as required when it was checked. I've got no adverse comments to make.
Any questions for Ms. Farrell? Don't see any hands going up. Mr. Cartier, would you like to speak to your application?
Nothing further to add at this stage. I do have a question relating to the planning, but I suppose when we come on to that, we can discuss it.
Are there any questions for Mr. Cartier? I suppose the one that I would like to ask is, have you looked into the planning aspects? I'll know it's nothing to do with us, but have you started that process?
Yeah, so there was in the letter I received, it was intimated that it may require planning permission and that I should do a pre-planning inquiry with the local council, which I did. I received feedback actually just 2 days ago to say that retrospective planning for so there is an outbuilding outside, which is a storage shed thing. The previous owners or proprietors of the building had used it in the past as a sort of extra bar area, as and when presumably during the summer months. And so retrospective planning would need to be applied for that. They also did intimate that decking as well would require planning. Anyway, I've sort of queried those 2 points. One, because it's not my intention to actually run the storage shed as any kind of bar. It's really just focusing on the garden and the courtyard area as external areas for drinking. And as with regards to the actual decking, I wasn't aware that decking required planning permission. I'm quite happy to have the decking removed, but I suppose those are all planning considerations. So if there is decking or if decking requires planning permission, in any case, it's well beyond its sort of life, so it needs to be removed anyway. So,
right. Any other questions for Mr. Cartier? Don't see any hands going up. Do you wish to sum up your application as Mr. Cartier?
I mean, as Julia's pretty much summarized everything, it's really just in order to ensure that it is actually compliant with the operating model that I had envisaged, and minor amendments in terms of, for example, serving breakfast to the public, not just to residents of the hotel, that kind of thing, particularly during the more popular summer period. Yeah.
Right, we're now in session. Members, we have an application in front of us. Just one point before I bring in Councillor Howie. Is there any issue with agreeing this application if the planning isn't in place, Ms. Traynor, or is that up to other authorities to worry about that?
The latter, convener. So planning is not a consideration for yourself. So you're just determining the application in terms of the matters before you today in terms of licensing.
Right. Councillor Howie?
Happy to support the application, convener.
Is there anyone otherwise minded? Councillor Thompson?
Not directly otherwise minded, convener. It was more just obviously if this does go ahead today, that it would probably be appropriate if we just let planning know, and then obviously if there is any issue or anything that needs resolved, and that can be followed up with their responsibilities. But rather than just we approve it and then it turns out a while later that something else should have happened or something else. But yeah, we can be proactive in our communication with other departments, but happy to grant. Thank you.
Yeah. So I see no other hands going up. I take it from that it's a unanimous decision to approve. And Ms. Traynor, if you could, once you've clarified to Mr. Carty the decision, if you could also maybe send a note to planning, or someone could send a note to planning saying that we've approved this for their information.
Thank you, convener. So, Mr. Carty, you've heard from the board today, and the decision is to grant your application in its entirety. You will be notified of that decision in writing in early course, and your revised premises licence shall be with you in early course. If I could just take this opportunity just to ask a member of the licensing team just to note the board's request today that the information of grant is shared with planning, just for that information sharing. If that could be recorded, and if perhaps a licensing team member could contact planning to advise of the board's grant today, I would be grateful as well. Thank you.
Right, yeah. We'll move on now to hearing 4, Masonic Arms Limited, 10 Ann Street, Gatehouse of Fleet. Miss Trainer.
Thank you, Convener. So this is an application for a major variation, hearing number 4 in respect of Masonic Arms, 10 Ann Street, Gatehouse of Fleet. I believe that we have a Richard Gidney, Director of the company licence holder with us today. Just checking that Mr. Richard Gidney is with us and that he can hear me clearly.
Miss Syme, have you something to say on this matter?
Yes, unfortunately, the licence holder has not joined the meeting, and during the meeting we have been trying to make contact with himself, his wife and the premises, and we're unable to reach him. So it doesn't look as if he's joining the meeting.
Do members wish to proceed in Mr. Gidney's absence? I take it silence as acceptance that we will proceed today. Right, I think we'll proceed with the application. Usual, we'll hear from Miss Farrell.
Thanks, Convener. Yeah, so this application relates to an extra outdoor drinking area. The premises currently has a fairly large outdoor drinking area enclosed within a walled garden, which has been operating for a number of years. This is a fairly new outdoor drinking area at the front of the premises, and it's adjacent to a row of car parking spaces. I've provided some photos just for information. The applicant confirmed to me that it's for 24 persons, so 4 tables that can seat 6 people maximum. No music will be played in the area. Last orders is the same as the rest of the bar, but likely the use of the area would not be after dark, and that the staff regularly patrol the area to clean and take away the glasses. They also built a bar in the current area which needed to be included in the layout plan, so this has been included, and I've shown a photograph of what that looks like. I've got no issue with that at all. Actually, from our point of view, a bar in an outdoor area is quite useful, in that if it's staffed, it means that there's an overview taking place as a staff member there, and who can supervise things that's happening in the garden. The one thing that I want to draw to your attention was the notice. It was due to be displayed on the 20th of December. So I made a visit on the 23rd, at which time I was unable to locate the notice. So managed to contact the applicant, but I was back at the office at that point, and he told me it was displayed within the summer house, which is sort of conservatory area. So I did go back to have a wee look at it, and my opinion was that you would, although it was there, you were unable to read it from the pavement. You would need to step within an open gate to be able to read the notice, which I just wanted to draw that to your attention. At that point, the applicant stated that he would put it in the window of the premises, which would have been much better in the first place if it had been there. But by that time, it was sort of a day before the last date for objections. So wanted to highlight that. Unfortunately, Mr. Gidney's not here to sort of provide his comments about that, but no adverse comments as such, but just concerned that the notice wasn't completely visible to passing members of the public. Thank you.
Right. Any questions for Miss Farrell? Councillor Thompson?
Thanks, Convener. Yeah, so Just on that, I suppose, is the notice still there? Given that the sort of date for objections is part, I'm just sort of thinking.
Yeah, I
that
believe.
Sorry, if it's displayed for public information, but the public can't access it without going into private property, that's obviously not in the spirit of natural justice, I suppose, for want of a better phrase. But and the other thing was just, and maybe the police will come on to this, but there was a reference to a suitable barrier structure next to the roadside in terms of the outside drinking area, and I just wondered, that's not part of your report, but is that something that would seem reasonable to you as well? Thank you.
Yeah, thanks, convener. I believe the notice is there. However, I haven't been back just to confirm that. He did tell me on the phone the day before the last day for objections that he was going to put it into the window. I've no reason to doubt that he wouldn't have done that, but I did say it would be raised as a preliminary matter at the hearing today. In terms of the barrier structure, you'll probably see from the photograph, there is some planters that sort of delineates the area, which any time that I've ever been, there's never been cars parked in that area. So I had no real issue with what's there, but obviously the police are maybe better placed to address that issue.
Councillor Barretti.
Maybe if I switch on the voice, thank you, convener. I was going to ask what Councillor Thompson is going to ask about the notice, but I'd also wanted to find out about the seating area that's on the area adjacent to the public road, because if I'm not mistaken, that is still actually public road, or it's a zone that technically Dumfries and Galloway Council have to maintain. Would that be right?
Thanks, Councillor Barretti. Yeah, I actually made contact with the council's road service because I was unsure of the ownership of that area ground. On speaking to the officer, it was a bit of a grey area, but given that there is lighting in the area, he assumed it was within Dumfries and Galloway Council's ownership. That's as much as what I could find out, so I didn't want to sort of include that in my report when it wasn't totally clear, but it looks like it is Dumfries and Galloway Council ownership.
Yeah, I don't. I'm still trying to ponder the consequences of that, convener, because from the photographs, if there's planters and everything else, and people wanting to potentially park there, but I'll leave it at that, convener. Thank you.
Right. I suppose question for Ms. Trainer, maybe based on the fact that the sign wasn't, it was visible but wasn't clearly visible unless you went looking for it. Should we be looking for this to be advertised again for the recommended period, or can we proceed today?
Thank you, convener. So that indeed is a matter for yourselves. You do retain the legal authority to require redisplay of that notice if you're not satisfied that it's been in place for the full 21-day period in a position that can be conveniently read by the public. I understand that the display dates were the 20th of December to the 9th of January. Then you've heard from the LSO that she visited the premises on the 23rd of December and was unable to locate the notice, which was apparently displayed in the summer house. You do retain legal authority if you wish to have that notice redisplayed, or indeed alternatively you can proceed to determine the matter today.
Right. I think that's a sort of preliminary thing we should sort of get out of the way first. Do members feel that the notice should be re-advertised, or are members happy to proceed today? Councillor Barretti?
Yeah, thank you, convener. Yeah, that was one of the questions I was thinking of, and you brought it up. And I think it should have been re-advertised, because if the members of the public, not maybe patrons of the Masonic, could not have seen it, there may have been objections, because we don't know how many objections there might have been, and we're not giving due justice to this application.
Is anyone otherwise minded? I don't see any hands going up. So I think that'd be unanimous that we would like the applicant to re-advertise for the appropriate period on a position that is easy for the public to see. Ms. Trainer?
So convener, the decision of the board today is to require the applicant to redisplay the notice for the full 21-day period at or near the premises in a position that can be conveniently read by the public, and for this matter to be determined at a future hearing date.
Yes.
Thank you. So today's decision of the board is to adjourn consideration of today's matter to a future hearing date to enable the applicant to redisplay the notice in accordance with statutory requirements. Thank you.
I have no other business. Next meeting date is Tuesday, the 4th of March. Thank you all for your attendance.
Thanks, Convener.
Thanks, Convener.
Thank you.
Right.